Hello, everyone. Thank you for joining us this afternoon for our presentation on the Michigan Homeowners Energy Policy Act, what board members and managers need to know. Brought to you by McCower Abbott Guerra Wagner Vollmer, where we help communities thrive. My name is Mark Petrie. I'm the firm's Director of Marketing and Business Development. And our presenter today is our firm partner, Amy Smith. Amy began her legal career in 2011, focusing on civil litigation, and became involved in community association law when she joined the firm in 2016. She now helps lead the firm's litigation team. Amy's practice is concentrated on litigation and collection matters for condominium and homeowners associations. She has appeared as a speaker on many community association legal topics, including with the Community Associations Institute, both at the state and national level. With that, I'll turn it over to Amy and we will get started.
All right, thanks, Mark. As Mark indicated, my name's Amy, and I just want to start with a quick disclaimer. We're here today to just provide general information on the Homeowner Energy Policy Act. This is not legal advice for any specific situations. So if you do have questions about how this directly impacts your community and you want specific guidance on that, you can feel free to follow up with us later. Today, I'm just going to be giving you an overview of the Act and its implications and as Mark said, the important things that you need to know about it. All right, so as you know, I'm sure you heard of, we're here to talk about today the Michigan Homeowners Energy Policy Act. And this is a new act. This is a new law that is going into effect. The effective date of this is April 2nd of 2025 this year. It was passed by the legislature last year, approved by the governor last July. And again, in just about 6 weeks here, it will be law in the state of Michigan. So the brief overview of the act and its stated purpose is to invalidate provisions in homeowner association agreements that prohibit energy saving improvements or modifications. We're going to talk about what that means in a minute here. And the second component of it is to allow installation and operation of solar energy systems without undue restriction. So we'll talk about what that means in a moment. As a preliminary matter, the Act does use the term homeowner associations. That's not a defined term. And I know that, most of you as board members or managers, if you think of HOA, you think of maybe a subdivision, not a condo. But the way that this is drafted, it does apply to condominiums and subdivision associations. So any community association in Michigan, regardless of the fact that they keep using the term homeowner association, this does impact you and is binding on all community associations. All right, so there's two key components of this act. There's two different categories of things that are addressed under the act. The first are called energy saving improvements or modifications. Those are defined to include, but is not limited to, things like clotheslines, air source heat pumps, ground source heat pumps, insulation, rain barrels, reflective roofing, energy efficient windows, energy efficient appliances, water heaters, electric vehicle supply equipment, which is an important one, and then energy efficient insulation. So the energy saving improvements or modifications is a broad term that encompasses all of those things. And those are treated differently under the Act as opposed to the energy systems. So solar energy system is the second category of things that are addressed under the Act. And that is what you're typically going to see as a solar panel, but it's not necessarily limited to a solar panel. It's defined as a complete assembly, structure, or design of a solar collector or mechanism that uses solar energy for generating electricity or heating or cooling. So it's a lengthy definition, but it's essentially the entire system that can use solar to generate energy. So typically you're going to see solar panels be in play there. But again, it's important to keep in mind that there's these two distinct categories of things because they're treated differently, and we're going to talk about how. Another key provision of this, before we get into those specifics, is that it is inapplicable to shared roofs in common areas. Now, this is very important because the Act does not apply to this at all. And how this applies to your community is really going to depend on the makeup and how the common areas are defined under your governing documents. Now, the Act does not use the term common elements like you would see in a condominium master deed, but how this is defined is a common area is a portion of a building, land, or amenities owned or managed by the association that is generally accessible to all members. And they provide some examples like hallways, stairways, outdoor open spaces, and common amenities. So the examples that they provided are, pretty straightforward, what you would probably think of as a common area. But how this applies to your individual community or the communities that you manage is really going to depend on the components of the community and how it's defined under their governing documents. So, where this act applies, we'd really have to be taking a look at the documents and figuring out how those items are defined. Now, if you think of a traditional site condominium where the unit is, the lot space, whereas there's the residence and the yard area, that is a little more straightforward. Same with a subdivision. The lot is, the individual yard, residence. That and what the common areas are in those communities is likely going to be a little more straightforward. Where this gets more complex and requires an analysis of the documents is, in the attached style communities, townhouse style communities. But again, things like hallways, open spaces, those are going to be common areas. The key component there being that it's owned and managed by the association and generally accessible to all members. And then it also does not apply to shared roofs. So if you're an attached condo that only has shared roofs, this may have very little implication for you. Shared roof is defined as a roof that serves more than one unit, including but not limited to a contiguous roof that serves adjacent units. So if your roof is attached and serves 2 or more units, that's a shared roof, and this act does not apply. So you may be thinking right now, I'm in an attached condo, we only have shared roofs, we have a lot of exterior common areas, does this even apply to me? The answer is going to be yes. One of the components of the act is adoption of a policy, which I'll get into later. But just keep in mind that because common area is defined as generally accessible to all members, even in an attached style community, you're likely going to have some limited common elements that are reserved for exclusive use of one owner, and so in that situation, a limited common element falls outside of that common area definition. So many communities, even if you're attached, have limited common element balconies or patios. So most communities are going to have some area, even if it's small, that is impacted by the implications of this act, and it applies to you. But if you only have shared roofs, when we get into solar panels and talking about that, just keep in mind that if you only have shared roofs, those provisions may not practically apply in your community. All right, so what does this act do? It invalidates any restriction in your governing documents that prohibits or requires approval for energy saving improvements or modifications. So that's a very broad implication. So in anything that's not a common area or a shared roof, the act says that anything in your governing documents requiring approval or any restriction on installation of those items is invalid. So within a unit and within a limited common element area, all of those things can be installed without association restriction or approval. Now, keep in mind that is clotheslines, electric vehicle charging equipment, rain barrels, insulation, those type of things, all can be installed without association approval. However, the important thing to keep in mind with that is it does not apply to common areas or shared roofs. So it still does not allow co-owners to make modifications to the common element areas, general common element areas, or the common areas without approval. So that's a critical distinction. Again, when you think of if you have a site condominium or a lot in a subdivision, installation within that lot or unit, the association is not going to have control over. So there's a lot more implication in those type of communities. In the attached style condominiums, you can still require approval for any common element modifications. But that's why it's really important to make sure that you're really analyzing the governing documents and what's being modified, just to make sure that you aren't placing some restriction on something that's not allowed. I know that in our practice, what the big question we've gotten so far in this area with these energy saving improvements or modification is electric vehicle charging stations. That's kind of the real big hot button issue with this. And when units are attached to each other, it really requires an analysis of the electrical system, what's common element, what is limited common element or part of the unit. And it may differ in every community what sort of restriction the association has on those going forward. So the key question here is, does it require a general common element modification? If it does not, then the association cannot restrict installation of those items that I had mentioned. The Act also says that any auxiliary change necessary for those modifications also cannot be prohibited. So that's not a defined term. They don't define the auxiliary changes. Potential examples of things that I've come up with are maybe upgrading an electrical panel to a higher capacity if it needs to accommodate increased power demands. Maybe reinforced posts or structural support for clotheslines, new ductwork for some of these appliances, those type of things. But again, that would only apply if it's the unit or limited common element. So, in a site condo, if someone needs to install some sort of auxiliary change to support energy efficient windows, those type of things, the association may not be able to control that auxiliary change as well. But again, it can still be restricted to the extent that it affects a common area or a shared roof. So that's really the overview of these energy saving improvements or modifications. This is given this is really a small part of the Act. It's a very, simple statement that unless it's on a shared roof or in a common area, anything that restricts or requires association approval is invalid. All right, so now I will get into the solar energy systems. So this is the solar panels, and this is given much more detail under the Act and how the solar energy systems can be restricted by the association or installed by the homeowners. Now, unlike the energy saving improvements or modifications, the provisions restricting solar panels are much more detailed and not as black and white. So the key component of this Act is that it's intended to allow co-owners to install these items, without undue burden or much restriction from the association. And the association's restriction, we're going to talk about what rights they have to control them, but it's pretty minimal and limited. And again, if you only have shared roofs in your community, this is the part of the Act that's practically not going to apply to you because none of what we're going to talk about with the solar panels applies to a shared roof or a common area. So essentially, the Act invalidates any restrictions that prohibit installation of solar energy systems or impose conditions that effectively prohibit them. So if your documents say no solar panels, that portion of your bylaws is invalid as a matter of law once the Act goes into effect. But most documents aren't that outright, prohibiting solar panels. So it's important to keep in mind how the association implements these provisions of the Act and what control that you do have. And that control is very limited. If you're talking about within a lot or a unit or a limited common element area. So if it's a common element, the open space, anything that's a general common element, the association still has control over that. And this Act does not require you to allow installation in those common areas or again on shared roofs. But if you're in a site condo or a subdivision, this is really important for you to understand, just because the association's control is so limited in any part of the unit. All right, so I'll get into the details of what the association can restrict in a minute here, but I want everyone to be aware that the Act requires adoption of a solar energy policy statement within 1 year of the Act's effective date. So the effective date of this Act is April 2nd of this year. So every association is required to adopt a solar energy policy statement by April 2nd of 2026. Now, even if you only have shared roofs and common areas and you're thinking this doesn't apply to us, the way that this act is drafted, you still have to adopt your policy. And the statute has very detailed, I think it's like a full page of items that need to be included in your policy. So there's extensive statutory required language in the policy, regardless of what type of community you have. If this barely even applies to you, you still have to say all of these things that we're going to talk about. So regardless of your community, the statutory requirements of your policy must be included. So one of the first things that governs for the policy is that it cannot conflict with any other laws. That's pretty straightforward. It needs to be compliant with other laws. That needs to be stated in the, it doesn't need to be stated, but it goes along with the policy. It can't violate any other laws. Now, here's where we get into the detail of things that may not even apply to your community. But the way the act is drafted, you still have to state. So the policy must state, or that installation, it must allow installation on roof faces or yard areas, except for shared roofs. So that potentially still applies in limited common element areas. But assuming you don't have shared roofs, your policy must allow installation on roof faces and yard areas. It also effectively, the act prevents the association from requiring any specific technology, make, or model, as long as it meets the definition of solar energy system. So the association has very little control over what type, make, model is being installed by the owner. The policy must state a few other things here. So it must state, regardless of your community, in reviewing an application for installation of the solar energy system, the association will not. So the association cannot do any of these things, and it must state in the policy. The association will not inquire into a member's energy usage, impose conditions that impair operation of the solar energy system, impose conditions that negatively impact any industry standard warranty for any component. The association cannot require post-installation reporting. The association cannot require a fee for submitting an application to install the solar energy system above which is assessed for applications related to other changes to the property. So it doesn't prohibit you from charging a modification review fee. I know that that's typical for many associations. There's a charge for review of a modification request. You can still do that, but it can't exceed what you charge for others. So it essentially needs to be treated like any other modification request when it comes to cost. And then the association also cannot prohibit a member from resubmitting a written application to install a solar energy system after the effective date of the act, which was denied previously by the association. So if you have someone who submitted a request to install a solar panel now in the past and it was denied for whatever reason, the law says that they are allowed to resubmit that request, and it must be reviewed under the new parameters of the act. So you can't rely on that's already been denied, we've already reviewed this. If they resubmit a request after April 2nd, you must re-review it within the parameters of this act. And then also the association cannot deny a member's application to install a solar energy system because of the identity of the entity that owns the solar energy system or the financing method. So I don't know if associations really inquire into financing methods, but that's prohibited. But the important part there is that you can't require a specific make or model or brand or something like that. The law prohibits the association from restricting those type of things. Now, you also can't inquire into a member's energy usage, like I said. So you can't ask, really, how much energy are you going to use? What are you hooking this up to? How much energy do you expect that it will generate? The association really can't inquire into what they're going to do with it. And you also can't require post-installation reporting. So after it's installed, the association can't go back and say, hey, how is this working? How much energy are you getting? The Act explicitly prohibits the association from requiring any post-installation reporting. So the association is going to have some control over this, right? There are certain standards that the association can impose. There's nothing in the Act that prohibits the association from having a preferred placement. For example, you can say, we would prefer that it be on the rear of the unit as opposed to the front, or in the rear yard as opposed to the front yard. So it's important to understand that the association can have preferences, but there's limitations on that. And the Act says that any standard that the association imposes on installation of the solar panels, it cannot result in reduce the production of electricity on an annual basis by more than 10%. And you cannot increase their cost by more than $1,000. So in Michigan, this is important because, you could say, hey, we prefer for these to be on the rear of your residence. But if someone, and I've already seen it happen, if someone says, hey, if I put this on the back of my residence, it's not going to work. It's going to reduce energy production by 50% over the course of the year. And in Michigan here, that's very possible for there to be more than that 10% reduction because of placement. If you're going to exceed that 10% threshold, then the association cannot impose that restriction. So if someone says, hey, if I put this on the back of my house, it'll reduce energy production by 50%, you would not be able to deny it and say that it must be on the back. They would need to be allowed to install it on the front if that is going to give them more energy production. So again, think of it like a preference. The association can have preferences, but you cannot enforce that and deny things or require removal if they can meet that 10% threshold. There's nothing that prohibits the association from requiring the owner prove that. You can say, hey, we need to know something from your engineer or whomever to demonstrate that, and then it would be on the owner to come up with something that shows, hey, this is going to reduce my energy production by X amount. But unless the association can legitimately contest that with confirmed numbers, your own engineering report or whatever, they may not be able to enforce that preference. And again, the preferences also cannot increase total cost by more than $1,000. So any restrictions the association places on, placement, if you want it shielded from view, those type of things, you cannot increase their cost by more than $1,000. All right, so the policy must also establish an application process. Again, regardless of your type of community, you must have an application process established by the policy. And according to the statute, it's required by the Act that the member's application that they submit to the association must provide certain things. So the application must state their name, the address of the location where they're going to install the solar panel, the name and contact information of the person that is going to install, so their contractor, whomever is going to install it must be disclosed. They also must submit an image that shows a layout where this is going to be placed on the residence within the unit, limited common element, whatever it is, they must submit an image that shows where it will be. And then they also need to submit a description of the system to be installed. So what are you installing? What are the specifications of it? The association can require all of those things. This is pretty similar to what you'd probably require for any exterior modification. You're probably already doing that, or even asking for the same stuff as it relates to solar panels. So really, when it comes down to it, a lot of this application process is probably similar to your current modification process. But that's all that the act says that the member must provide. Now they need to do that, but it's, pretty straightforward information. Now, another important thing to know about the act is that the association can't require approval of any other member of the community, including anyone that is adjacent to the unit or lot where the solar energy system will be installed. So you can't say, we'll only let you do this if your neighbor approves it. But yeah, you can't require any other member in the community to approve this in order to allow the installation. So if a neighbor is really upset about it, the association can't make its determination based on that. You're prohibited from considering, what the neighbors think about it. Obviously board members as a member of the community will have a vote as a board member. But again, the community members themselves cannot have any say in these. In terms of timeframes, the board must approve or deny applications within 30 days of receipt. So it is very important to make sure that you're monitoring for these specific type of requests and that a decision be made within 30 days. Now, within the first year after the act is adopted, if a policy, because again, remember that the policy doesn't need to be adopted until April 2nd of 2026. So there's going to be a year time frame where the association is not statutorily required to have its policy yet. So within that year, if the board has not adopted their policy, then they have 120 days to respond to the request. So just keep in mind that once you adopt your policy, you're within the 30-day time frame. If you don't have it yet, you have 120 days. But the point there is, the legislature, I think, recognize, it's going to take time for people to know about this. Boards may not be aware of these requirements. So they give a little bit more time. But if the decision is not made within 30 or 120 days, then the application is deemed approved and the member can proceed with installation so long as it's compliant with the act or the association's policy. So if it violates the act for other reasons, then that could still be considered an unapproved modification. But if the application and the installation meet these statutory requirements that I think we're going to talk about next, then you can't treat it like an unapproved modification and require removal. People can proceed with compliant installations regardless of whether they have received approval. And the act says that you really can't do anything to enforce it against them unless it violates a law or one of the specifics that we'll talk about on the next slide. And again, keep in mind there too, that if you get a request that was previously denied, you are obligated by law to re-review it under the act and make a determination based on these new restrictions. All right, so this is probably on your mind, is when can we deny it? What are the specific restrictions that we can put on these? What does this allow us as the board or manager to do? And what can we restrict? Now, of course, as we've talked about, installations on shared roofs don't need to be permitted, and an application to install on a shared roof can be denied without any liability under this act. Now, in terms of aesthetics, so there are some specifics that are set forward in the act regarding what restriction the association has on aesthetics. So the association does not need to allow installation of a solar panel or system that extends beyond the roof dimensions or does not conform to the roof slope. So there, that means if it's wider than the roof or it was going to, extend beyond the lower edge of the roof, that doesn't need to be permitted. It has to be within the roof dimension. So it has to be actually on the surface of the roof and cannot extend beyond that. And it also must conform to the roof slope. So if you have a sloped roof, you don't need to allow something that's, sticking out. You can require that it be conforming to the roof slope itself. And then in terms of aesthetics, the association can require a frame, support bracket, or visible conduit or wiring that is silver, bronze, or black tone, or any other tone that's commonly available in the marketplace. So in terms of color and aesthetics, the association can require that it be limited to silver, bronze, or black. So there's where we get a little bit of, aesthetic control to try to, bring some uniformity to the community. And really what we're looking to is what's commonly available in the market, which I think is the bronze, black color. And then when it comes to the brackets or wiring, you can limit that to those colors in silver as well. Of course, another thing that must be in your policy and is in the act, that if a court has found that the installation violates a law. So if for some reason you have a court order saying, hey, you can't do that, then they try to maintain it or, reinstall it. Of course, you can deny it for that reason because the court's already found, hey, this doesn't comply. If the installation does not substantially comply with their modification request that they had submitted and the board approved, then you can potentially pursue it as an unauthorized modification, just like you would with other exterior modifications. Hey, we approved A and you did B. That is actionable and something that the association could pursue as a violation. There I would just caution, it probably is going to depend how different it is and if it otherwise meets some of these requirements. On a case-by-case basis, we would need to think through, hey, is this really worth pursuing as an unauthorized modification? But it is still possible if they substantially deviate from their original plans. And then also, the solar panel does not need to be permitted to extend from the roof more than 6 inches. So if the installation is more than 6 inches away from the roof surface, that can be denied and does not need to be allowed. So the goal here was to, keep things in accordance with the current roof slope dimensions. It can't extend more than 6 inches above the roof line, and we have that restriction on color. So there is some aesthetic control built in here for the association to try to build uniformity, but as you can see, beyond that, it's pretty limited what the association can really restrict and deny a modification request because of. And then also, part of the act is not only does the association need to permit installations on non-shared roofs, but it also needs to permit yard installations. Again, unless it's a common area. So here we're really talking about your, site condominiums, subdivisions, where people have yard area that's part of their unit or potentially a limited common element. If it's going to be installed in a fenced yard or patio rather than on the roof surface, the system cannot be taller than the fence line. So this is a strange provision because if there's no fence, then there's no height restriction on the solar panel installation. But if there is a fence, then the association can say, hey, you can't, this can't be taller than that fence line to try to shield it from view. So just something to keep in mind as you start working through these in your community, that is out there if there is a fenced yard or patio area. The members also must comply with code and permit requirements. So this act does not get people out of getting permits, following code, those type of things. All of that must be done like it would with any other exterior modification. And then, when you think about enforcement, maintenance and repair, that's a big question that people have too, is, this act is very focused on initial installations and what must the association allow. You have to allow solar panels on non-shared roofs, within units or non-common areas. And you have some but limited control over the aesthetics. And so the act is really focused on initial installation. And then from there, I think that it'll be, sort of like any other modification request, an exterior modification, in terms of maintenance, repair, enforcement, that kind of thing. You can continually enforce that it be compliant with code. And then of course, for installation, they need a permit as well. I'll talk a little bit about maintenance here. So first though, I just wanted to make clear that once you adopt your policy, and again, every community association needs a policy, regardless of what type of community you're in. So you need all those things that we talked about to be stated in your policy. And then the policy must be communicated to the membership. So the act states that the policy must be made available to association members within 30 days of the adoption of the act, or upon request. So once you adopt it, it has to be made available to people. There's not it doesn't define available. So it doesn't say you must mail it. It doesn't have any specifics about how it must be communicated. So you could send it out via email, post it on the website, direct communication. The made available is not defined and is not a mailing requirement. Again, maybe in your community, you will have to mail it out just to make it available to everyone if you don't have email addresses or a website, but it's not required to mail it. Now, the act specifically does say, though, that if your association maintains a website, it does have to be posted on the website. So that's the one strict requirement that we get here in terms of distribution is if you have a website, it must be made available and posted on your website within 30 days of when it's adopted or upon request. So if someone comes to you and says, hey, can I have a copy of the solar policy? It must be provided to them within 30 days. So that's something to keep in mind. You can't say, it's on the website. You have to make it available and provide it to them if they ask for it. Again, just to make sure that people can get it into their hands if they want it. All right. And then in terms of maintenance and repair. So again, like I was saying, there's no real or very strict requirements of the act when it comes to maintenance and repair by the member. So again, this is really focused on that initial installation and allowing that to proceed. From there, there's nothing that invalidates provisions in your governing documents about people complying with code, maintaining things properly, those type of things. But you cannot make it more burdensome than for non-solar projects. So really you're going to be enforcing this like you would other exterior modifications. So if wires are hanging out, if the solar panel is falling off the roof, of course, in those situations, you'll be able to say, hey, you need to fix that. It needs to be sightly, it needs to be code compliant. But again, you can't impose restrictions more than you would with any other exterior modification. So that's just something important to keep in mind. But also going back to what we said earlier, you also can't require any post-installation reporting. So I think here is where board members and managers need to be careful because, you can have reasonable conditions on, maintenance, making sure it's sightly, making sure it's not falling off the roof or in disrepair, but you also can't require any post-installation reporting. So I would just caution you, I wouldn't be asking, hey, are you still using that? That's potentially post-installation reporting. So by way of that, you can't necessarily require someone to continually use it. If they have the solar panel they put up and they're not using it, you may not be able to require removal just because they're not using it anymore, because you can't have any post-installation reporting and you can't ask if they're still using it. So you're really limited to those, aesthetic type things when it comes to ongoing maintenance and repair. But you do have that ability to enforce your documents and say it must be sightly. You need to keep it up with code requirements, all those type of things. All right. So there are consequences laid out in the act if there's a violation. So a violation could be not adopting a policy. So every association needs their policy by April 2nd of 2026. And if you don't have a policy in place, that's a potential violation of the act. If your policy doesn't strictly comply with the act's requirements, that's a potential violation. If the board is denying requests that they should not be denying, that's also a violation. Or, I know we only talked briefly about the energy saving improvements and modifications, but if you're attempting to restrict those at all in a way that's not permitted, that's a violation of the act. So the act does give a civil cause of action against associations by members. So the act says that if the association is violating the act, any member can bring a cause of action. So whether you denied something you shouldn't have, you don't have your policy, a member has the right under this act to initiate a civil action against the association for enforcement. And there's an attorney fee provision built into the act. So it says that the court may award damages or attorney fees. So it's not required, but it is a possibility that an owner or a member, if they're correct that the association is in violation of the act, the court has the right to award them attorney fees. So it could be a pretty significant penalty. So that's why it's really important for your association to make sure that you're complying with the act, especially by implementing your policy. Again, even if you only have shared roofs or common areas, still adopt your policy because you could be liable for attorney fees if someone brings a cause of action successfully. All right, so we're going to get into some questions here in a minute, but I just wanted to do a brief recap of the importance of this act, implement the policy, and modifications of older policies that don't comply. So the key components of the act are for energy saving improvements and modifications. Those are the items that we talked about other than solar panels. The association can't restrict those within a unit, a lot, or a non-common area. So no restrictions can be enforced in those areas. And again, what the boundaries of that are really going to depend on your governing documents. And when it comes to the solar panels, the solar energy systems, the association is restricted in what they can do. So not only do you need your policy and you need to establish your application process, but the association has very limited control other than, again, ensuring that the solar panel complies with or is within the roof dimensions, conforms to the slope of the roof. You can only you can require that it be silver, bronze, or black, but that's kind of it. And the solar panel can't extend more than 6 inches above the roof face. And then for yard installations, the association does need to permit them if it's not a common area. And the solar panel or the solar energy system can't exceed above the roof line. And that's kind of it. And from there, if the association has preferences or other restrictions that they want to try to impose, they cannot increase the cost by more than $1,000 and cannot result in reduction of the energy production by more than 10%. So I think the biggest takeaway is make sure you're adopting your policy because that applies to everyone. And again, you could be liable for attorney fees if your policy doesn't comply with the act. So I would definitely encourage you to, seek legal advice when you're adopting your policy, just to make sure that the way it's drafted and the way that you're implementing it in your community strictly complies with all of these statutory requirements. And again, you may need to modify or look at older policies that don't comply. Now, the act is going to supersede those by law. But if you have policies, the one that comes to mind is maybe an electric vehicle charging station policy. That's something you should probably re-review because this act may have implications for those type of policies. So those type of modifications that like an EV charging system or some of these other exterior modifications, if you have current policies, I would really encourage you to have those re-reviewed just to make sure that you're addressing these things in accordance with the act. All right, so that's an overview. I know Mark said we were going to try to wrap up by 1:30, so we definitely have some time for any questions that you have.
Yes, thank you very much, Amy. I do see we have plenty of typed questions here. We have some
Mhm.
folks with their hands raised as well.
Great.
Um, and if you'd like to raise your hand, you can do that with the menu at the bottom of your screen. Let's go ahead to Marilyn here. Marilyn has a hand raised. I will go ahead and see if Marilyn's there. Marilyn, are you there?
Yes, I am.
Terrific.
Yes, I have a couple questions. One, with regard to after installation reporting, would a request to confirm the height from the roof be considered a after installation reporting, or would that be okay?
No, that would be okay. And when it comes to those specific things that the association can control and enforce, that would not be considered post-installation reporting. I think the intent there is more about energy usage, and the usage of the system itself. But certainly confirming if it complies with a modification request or the statutory requirements is permissive.
And my second question is with regard to installations within the yards. And the yard portion would be a limited common element.
Mhm.
If that, and I'm assuming it's allowed in a limited common element, is that correct?
That's correct. Again,
Okay.
you don't need to allow modifications to the general common elements, but if it's a limited common element area, it's unlikely that meets the definition of common area because a critical component of that definition is accessible to all members. So by definition, a limited common element doesn't meet that. But again, if it's you'd have to look at what type of installation it is, and if there are common element modifications to the general common elements, that doesn't necessarily need to be permitted.
What, um, in that case, if it's a limited common element, they want to put it in there, but obviously in condominium associations, or most of them, the mowing of the lawns are done by the association. And what if and most of those are not hand mowed, right? They're riding mowers. And those interfere with getting the person's lawn mowed. And I could foresee an association saying, well, if we can't mow that, then we're not mowing your lawn. So
Mhm.
how does that situation play into this?
I guess we'd have to look at exactly why they can't, or if there would maybe be an increased cost because of it. If they really can't mow the lawn and provide that service, then I guess the association would be taking the position that, hey, we can't do this because you can have your installation, but because of it, we can't perform this service. But I think you would also need to explore, can it be done even if there's an extra cost? Because it's likely they probably could do something at an extra expense. And there's nothing in the act that would prohibit the association from having the owner pay for that. We'd have to do an individual analysis with that, if it depends what it is. If it's a solar panel versus one of those other energy saving improvements or modifications, that's really just going to depend on the facts and the costs and, what could be done, or is there any alternative to determine if you can
Okay.
assess those costs back.
All right, thank you. That's all my questions for now.
Sure. Thank you.
Thanks, Marilyn. Okay, and moving, we have some typed questions here too. We'll pepper some of these in. This is an interesting one. Do low E windows apply? Can the board deny low E windows because they have a green hue and tint to them? They might not like the color. Just to give a definition for those who don't know, I I Googled this quickly. Low E or low emissivity glass was created to minimize the amount of infrared and ultraviolet light that comes through your glass. And it has a coating that is transparent and reflects heat.
So if I'm not familiar with them, but if the point of that coating is for energy saving purposes and they meet that definition of an energy saving improvement, the association couldn't deny it just because of the color, because they can't place any restriction on those energy saving improvements or modifications. So it can't be denied for color purposes. But I would definitely take a close look at, is that actually saving energy? Because if it's not actually generating an energy saving, then it may not even fall within that definition, and then you could address it like any other modification.
Great. All right. Let's move to another person with their hand up. Let's see. We have Dee here. And Dee, are you there?
I'm here. Thank you for putting the seminar on. It's very timely.
Thank you.
My question is, okay, so there's like going to be hundreds and hundreds of associations trying to put together their policies.
Mhm.
Does your firm have access to like policies already created, maybe from other states, that we can use as a template? It's like, why should hundreds of associations try to invent new wheels,
Sure.
unless we have a template to go by?
Mhm. So our firm has created a policy. A lot of the language that's required to be in your policy comes straight from the act. So a lot of the stuff that I talked about, the act says your policy must state these things. So you could go in the act and extract that language, and your policy has to state that. Where these policies really need to be looked at on an individual basis is, how does this apply to your community? What are your general common elements? What's defined as the unit? So the policy needs to be drafted not only to incorporate the statutory language, but to properly be implemented under your community's governing documents. So we have developed policies and we draft them, but all of them are going to be customized to the community. Just for reference, it takes us about 1.3 hours to draft a policy. So at our hourly rate of $335, it's about $430 to draft the policy. So while a lot of the language looks similar from policy to policy because of the Act's requirements, again, what your association can really restrict is still going to have to be looked at based on your master deed or your declaration.
Thank you.
Yep. All right. It looks like Dan is next.
Yeah, I didn't hear the moderator introduce me, but
Oops, gotcha. Sorry, I had to unmute myself.
no, that's okay. I was just waiting for that. So thank you, Amy. This was a very beneficial presentation.
Thank you.
Really appreciate it. I'm learning a lot. Some good questions. And I'll thank you as well as Jim Toko, who drafted our community's solar policy. And I've got a few questions. I think I'll start there.
Yeah.
Which is, I found it interesting that lack of a solar policy grants a greater time frame in which to respond to an application. So even though we have this in hand, our board of directors has yet to adopt the policy. And I don't want to sound callous here, but of the 171 members in our community, 170 are very opposed to this concept. So would it be unreasonable to deny applications on the basis of not meeting the specific administrative requirements, because that's our only pathway to deny an application, and just simply ride out that 120-day period over and over with the intent and hopeful expectation that under a different administration, this law will be repealed? And I have a couple other very much quicker questions.
So the important thing to keep in mind is once you adopt the policy, then you go into the 30-day world, right? Even if the policy is drafted in hand right now, if you have not, as the board, adopted it, then you still have your 120 days. So you could take 120 days and then adopt your policy on April 1st of 2026 if you want. But the important thing to keep in mind is that the act is still binding. So if you get a solar panel request, you still have to review it eventually within these parameters. So it's not like the requirements don't necessarily kick in when you adopt your policy. It's when the law goes into effect. So you're buying yourself a little time if you don't have your policy, but it's not changing how you need to review these, if that makes sense.
It does, but I think my intention would be not to adopt the policy to give us 120 days per review. And if there is an administrative error in the application, they would have to resubmit and it would start the 120-day clock. And we'd only have to adopt the policy after the first approval. I think I've got that right. But
That's correct. Yeah. I mean, you have until April 1st of 2026 to adopt your policy. So you can do it at any point up until then. Yeah.
okay, thank you. A quick clarification with regards to the preferences that can be enforced as long as they don't create a greater than 10% cost increase, excuse me, $1,000 cost increase or reduce electricity generation by more than 10%. Is the onus of proof for that, was that on the homeowner or the association? We can demand that information from the homeowner before approval, is that right?
Yeah, so that's not strictly addressed in the act, but I think as a practical matter, you could say, hey, you need to, if you say, hey, we prefer for this to be in the backyard area, and someone says, no, I have to have it in the front because of the energy production, it would be on them to prove that that's the case. Now, if they provide that information, then the association would need to be able to dispute it. And so that you just need to look at it on a case by case basis. But yeah, if the owner says, hey, I can't do that, it would be on them to explain why.
Okay, very good. And I think by inference, we can deny any application prior to April 2nd of this year, 2025.
Yes, the act is not in effect until April 2nd. But again, they could resubmit it on April 3rd and you'd need to re-review it.
Okay. Color requirements, can we be specific as to the application? For example, one set of commonly available colors or the list of the ones you provided that are in the act might work well for one home, but not another. Can we differentiate, or do we have to decide on that as a broad color for the community?
That's a good question. Let me look at the language here. I think based on the way it's drafted, you would need to allow all of them.
So we would give them the options and the homeowner would choose.
Yeah, black, bronze, silver. Mm-hmm.
Okay, we can't pick one and demand it. Okay.
Right.
And then the last thing, and thank you for your patience to other people who have questions. The last question I have is related to insurance. We've come to understand from various sources that homes with solar panels are increasingly becoming scrutinized by insurers and may be denied homeowners insurance because of it for a couple of reasons. Number one, they tend to fail, cause leaky roofs. Other examples or anecdotes that we've come across is unproven technology, raising the question to the insurance company as to what health implications that would have on the members of the residents.
Mm-hmm.
And so would it be possible within the law to require proof of insurability of the home?
It's something you could request. I don't know if it could be denied if they won't provide it. It's one of those, like, I would think of like a preference. It's not a explicit reason for denial, because the act is specific about you can only deny it under limited circumstances, and lack of insurance is not one of them.
Okay.
If I guess it would is if in like a site condominium, say, you know, if there were to be a lack of insurability or something, that liability is really going to fall on the individual owner if something happens. So we'd have to look at your documents if that really became an issue, but I will say that it's not a explicit reason under the act for denial. So I think that might be tough to say you have to prove insurance. But there may be another requirement under the bylaws that if your bylaws require co-owners to have insurance, that may be another enforcement route to say, hey, okay, you can have this, but you also have to have insurance, and that's sort of a separate violation.
Okay, great. Thank you very much.
Yep.
Okay, thanks, Stan. Great question again. And then let's see, we have another type question here I thought was interesting. So this person is a condominium association, not a homeowners association, and their bylaws state that no solar panels are allowed. Would this apply to a condominium association? And you mentioned briefly their site condos.
Mhm.
So I guess just maybe give an overview of the difference between site condos in Michigan and
Yeah,
how that
so
might differ.
yeah, so a site condo it's established as a condominium, but the units are individual lots like you would think of in a subdivision. So the residence and the yard area, all of that land is the unit itself. And the answer is yes, it applies to all condominium associations because it uses the term homeowner association, but that's not defined. And the way that this is drafted, it is drafted and intended to apply to all community associations. So even in the condominium context, it would apply.
Great, thanks, Amy. Let's see, we have another question from John here. John, I'm gonna allow you to unmute. There you are.
Hi. So we're in a 127 unit condo association that actually provide legal advice to us, and I'm finding this very helpful, this call.
Good.
But we have 33 buildings, and they all have shared roofs, so we're good that way. However, people can have decks, if they want to install them. So that would probably be considered, I'm guessing, a limited common element.
Mm-hmm.
And I guess they could put a solar thing on the deck. I'm not exactly how, but I mean, it's anything's feasible. So
Right.
It sounds like we would have to allow that or entertain it in our policy that we're obviously going to have to write.
That's correct. So assuming that it is a limited common element area and the installation would not modify any general common elements, then the owner would be able to install it there.
Okay.
Mm-hmm.
Great. Thank you.
Yep.
Okay, thanks, John. And let's see, we also have Andrea here. Andrea, I'll allow you to unmute there.
Thank you. My question is, can you speak to a charging station in a carport right outside your unit?
So typically a carport, and this is a document specific question, but I would say typically the carport structure and electrical is a general common element. And we typically see just the parking space itself defined as a limited common element. So the association can likely restrict that because it would need to be installed on the general common element carport structure and modify the general common element electrical. So when you get into general common element modifications, yes, the association can restrict it. If it truly only modified a limited common element, then you may not be able to, but I think in a carport situation, it's likely you'll be able to, but it is document specific.
Thank you.
Yep.
Thanks, Andrea. Let's see, we also have Suresh. Suresh, I'm going to allow you to unmute here.
Thank you. Thanks for taking time to do this seminar, webinar, very informative. I have three questions. Most of them are probably simple to answer. One is in our site condo, we have restrictions on what neighbors can do with their front yard and side yards. We generally allow what they can do with their backyards. Could we limit the solar panels installation based on where they are installing on the side yards? Because our bylaws do restrict what they can do or in the front and side yards.
So any provision in your documents that conflicts with this is unenforceable. So you wouldn't necessarily be able to directly rely on that. You can have preferred placement is what I'm calling it. Like you could say, we want this in the backyard, and then leave it up to the owners to say, hey, no, my energy is going to be reduced by X amount, and try to address it that way. Because in the majority of situations, if it's a yard installation, they probably can use the backyard, but it really just depends like which way their unit is facing, if there's like trees or whatever. So you wouldn't be able to say, we can restrict those areas, you can't have a solar panel, because the act invalidates that.
Yeah, our neighborhood is a fenceless neighborhood. It's like
Yeah.
wide open. So even in that case, it applies then, right?
It's likely that you'd have to allow them.
Okay. Okay. The second question is a small follow-up about cloths line, right? I mean, if the same thing applies to cloths line too, like can we restrict use of cloths line, I guess?
So you can't have any restriction. So again, you could say, hey, we would really like if you put these in the backyard, and that could be in your rules, but it can't be a restriction and it's not enforceable. So if you say, we really want you to put this in the backyard, and someone puts it in the front yard, there's nothing you can do about it.
And even unsightly, because normally unsightly is something that we get reported on because a neighbor doesn't like cloths line. Is that's also not allowed in this case?
Yeah, I mean, if it's in disrepair or there's some other provision we can invoke that's not invalidated, then there's potentially enforcement action. But if it's, in good condition and it's just there, then you wouldn't be able to restrict it.
The last one is follow up to an earlier question. So if someone wants to install it for their EV on an easement area, that's a permanent installation. Can we deny that because the charger is in an easement, utility easement?
Are you referring to it being in a common area or within the unit?
Within the unit.
The association can't have any restriction on it. If it violated the terms of the easement and there's another reason to deny it, that's something we'd have to take a closer look at. You'd need to look at the easement language and figure out if it violated the easement or it would implicate the association in that way. But as a matter of course, it's going to be hard to enforce restrictions within the unit.
Okay, sounds good. Thank you.
Thanks, Suresh. I have another type question here from Amber. Interesting question. Who is responsible for cost of removal and replacement of panels? Solar panels, I assume, if the HOA is replacing a roof?
So that question, I guess I would need more context, because if it doesn't apply to shared roofs. If the association is responsible for a non-shared roof, then it's likely the association would be able to hold the co-owner responsible for those costs. Because there's nothing that prohibits the association from pursuing an owner for these extra expenses. There's nothing that says the association has to pay for all of that. It just allows the co-owner to install it. So if they're installing it on a non-shared roof that the association is responsible for, then the owner would be responsible for those type of removal and replacement type things.
Thanks, Amy. And is that the sort of thing that you want to make sure goes in your policy then?
Yes, if you're a community where you have non-shared roofs and the association is responsible for it, then you would either put it in your policy, or you would require like a modification agreement or something when it's actually installed. That would be a reasonable condition upon approval. To say, hey, we want a modification agreement that confirms, what the co-owner's responsibility is for it.
Great. Okay, we still have plenty of questions here. Let's see. We'll go to Stephen with the hand raised here. Let's see, Stephen there.
Thank you.
I think we got you.
Thank you. Yeah, unmute. Thank you, Amy. This has been great. Appreciate it. Just a couple quick questions.
Sure.
This policy, once it's adopted, what is it? I mean, we have governing documents, a master deed, bylaws. We have rules and regulations. Is this a
Mhm.
third category of a governing document?
No, I would think of this just like a rule. You know, the board adopts it, it's distributed to the community and or made available to the community. So it's more of a rule.
And these policies, who's monitoring it? We adopt the policy. Does it get filed with somebody, the state, or?
No, it's just something the association has to do. And again, if you don't, it's up to a member to bring a cause of action.
Okay. And again, some of these other ones, for example, someone wants to put some poles up behind their unit for clothes, and they dig a hole, put some cement in, stick a pole in there, and it's great for 5 years, and then they move,
Mhm.
and the new owner's there, and it's falling apart or whatever. How do you memorialize or make sure that the next owner knows they're responsible for these poles?
So, I mean, if it's within the unit or a limited common element, then the document should put someone on notice that they're responsible for it. If you're allowing it in a general common element area, then that would be done with a modification agreement like you would with other exterior modifications. If it just depends, like if it's something the co-owner is already responsible for, which is really the intent of this, is to allow people to install these in areas they're already responsible for. The documents put them on notice that that's their responsibility. But if it's not clear, then it's likely we could do some kind of modification agreement that gets recorded against the unit.
Lastly, for our EV rule that we have in place, which basically states for approval, I guess we have to modify that. But can we still require the modification to make sure it meets the city and county and state rules, that they use a certified electrician, that they get the appropriate permits? Is all that still allowed in an EV policy or rule?
Yeah, I mean, being code compliant and compliant with other laws is still allowed. But again, that's where we'd have to look at your documents for your community and figure out, are they actually modifying common elements? Because if they're modifying a general common element in order to install this, then the association has all of its normal restrictions on approval, modification agreement, all of that.
Well, this would be, let's say, in a garage, which I guess would be a limited. I'm not sure.
Mhm. Yeah,
If
and that
that's a
depends.
limited.
I mean, a lot of in many situations, the general common element electrical system is defined as a general common element up until the fixture, which if it's behind the wall and it's a common element, it's likely going to require modification. But so in a lot of situations, it's still making common element modifications.
Okay, great. Thank you.
Yep.
Appreciate it.
Okay. Thanks very much for that, Steve. Let's see, we have Dan here. Dan, you can go ahead and unmute if you like.
All right, thank you. And yeah, thank you. This has been very good. Obviously, this whole policy is upsetting because it seems unreasonable on many respects. One of the questions I'd written in was with regard to, we've got a small group of site condos here, 24, and, the big appeal of the neighborhood was a lot of the aesthetics. And so my question that I wrote in, I'll just ask it here, was what you're saying is someone could decide they want to put some solar panels in the front yard, and since we don't have fences or whatever, it could be as big as a person would choose, and that would I know no one in this neighborhood would want that. Yet if someone did that, it sounds like we would be forced to accept it. Is that true?
Likely, yes.
Okay. You know, a lot of the other questions have been asked. I was intrigued by the insurance one. I think that might be a good avenue. Also, it seems that, you know, indemnification to the association might be something to consider in the policy, just for a variety of reasons. When these are put out. But has your law firm monitored, or is there any talk of potential modification or repeal of this policy or this bill that was put forward? I didn't follow it at first until it became, so I don't know how it came to be, but it really seems like there's a push, you know, behind it, maybe from the, you know, the electric company or environmental side, but it really seems very one-sided. I guess if you were going to say it doesn't have any flexibility to it, which seems unreasonable.
Sure. So there was, so obviously this act passed in the last legislative session and it's being signed into law. There was a bill that was introduced in the 2024 legislative session that proposed a repeal, but it never got anywhere. And because it didn't get anywhere in 2024, the bills die off and they need to be reintroduced. So it's not pending right now. But the information that we've heard is that it is going to be reintroduced. So it is possible that the repeal of it could get somewhere. But as of now, there's not even a pending repeal bill. So I just don't know where that's going to go, but it's possible. It's possible that, you know, the concept of a repeal could turn into maybe some revisions to the act, just to give a little more clarity or, you know, control to the associations in some of these situations like we've been talking about where, you know, these are attached communities. Their components aren't exactly, you know, as simple as you would think of in, you know, an individual lot situation. So it's I think it's possible that maybe revisions come of it, just to, you know, eliminate some of these concerns that, you know, we've been talking about today when there's, you know, these shared components of the community.
Okay. All right. Thank you.
Thanks, Dan. Let's see, we had another type question here, some other ones that are similar to it. When a unit transfers ownership, can the HOA require removal?
No, so there's nothing in the act that allows the association to require removal just because of a change of ownership.
Thanks. Let's see, we have Linda also asks, in an attached condominium, are there any restrictions that can be imposed on placement of rain barrels or clotheslines on a deck or a limited common element patio?
So again, not that are enforceable. So because you can't have any restriction in a unit or limited common element area, it would again be up to the board to say, hey, we'd rather have you do this and have a preference. But if someone installs it and it's not a common area or shared roof, the association really can't do anything about it.
Right. And let's see, we also have some other hands raised here. Here's Bernadine. Let's see, we'll get Bernadine here. You can unmute yourself there, Bernadine.
Thank you. I want to also thank you for doing a great presentation today. We have an association that governs 355 units. Some of the units are standalone condos, not too many, but there's about 30, and most have shared roofs. So would that require us to have a different policy for part of the association that is a standalone condo?
Possibly. Yeah, so any shared roof this wouldn't apply to, but if there are standalone units, I mean, unless the roof is defined as a general common element, so that's again a document specific thing, but in general, if the roofs are part of that unit or a limited common element, then the association would have to treat them differently. So it is possible to have different outcomes, you know, with the different unit styles.
Okay. And then the policy, does it have to address everything? It seemed like there was a lot of time spent on the solar panels, but does it also have to address the rain barrel, the clothesline? Does everything have to be specifically stated whether we do allow it or do not?
So there's a lot of specifics like you recognize with the solar panels. With the energy saving improvements or modifications, that category of things, all you need to state is that the restrictions within the unit are unenforceable. So unless it's a common area or a shared roof, the restrictions aren't enforceable. So really that area or portion of the policy is much simpler since there's really nothing that the act says the association can enforce.
Okay, thank you.
Yep.
Hey. All right, thanks, Bernadine. And let's see, we also have Martha here. Martha, you can go ahead and unmute.
Hi, thank you. This is really helpful. And we are having you write up our policy, and thank goodness we are, because I would not want to tackle this without legal help on this. So these questions are great too. So this is kind of on the mowing thing. We have attached condos, attached roofs. So I know we're safe in that aspect.
Yeah.
There are a few people that aren't happy that we're not allowing it because they're attached. They can't understand why.
Sure.
But my question is, so I know that we have a very small footprint, we call it kind of footprint or limited common area along the side of the condos. So we could have someone who would want to put their solar panel in their front yard underneath their window, so to speak, because we have to allow them, right?
Right.
Right. So my thing is on the mowing. Okay. So one of the original questions. So we have a lawn service and they use big mowers and weed whippers. Could we be allowed to charge that owner a fee that we would be charged by the mowing company to do push mowing or very gentle mowing around that area so that a rock doesn't, because I'm sure that mowing company is not going to want to be held liable for, a stone flying up and cracking the panel.
Yeah, I think you can. As long as that's like the lowest cost, best alternative, then there's nothing that would prohibit you from assessing that cost back to the co-owner. The act doesn't say the association has to absorb the costs related to this, and if it impacts the other association services, just like you would with other modifications, right? You would, if someone wanted to install, something that affected the mowing, you would charge that back to them. So as long as you would do that for others and it's the best option, then you likely could assess it back.
Okay. Yeah, it's just yeah. I mean, I hate to sound petty on that, but we live in northern Michigan and we don't have a ton of mowing companies
Sure, yeah.
And so we would not want to lose one because of this situation. So,
yeah, absolutely.
And them being fearful of, damaging it and then having to pay for it or something. So
sure, absolutely. I get it. Yeah.
Is there such a thing as insurance on solar panels if something like that happens, or what?
I don't know if it would be insured against that increased cost.
Okay.
For the services. I'm not sure.
No, I didn't mean that. I guess that's a side question so would there be an insurance for anyone, even if they had it on the roof? Does a homeowner have special insurance if something were if a limb were to fall on it or something? Is that?
I'm sure. I think that you would probably have to add it to your homeowner's insurance policy. I'm sure it's possible to have that added.
Okay. All right. Thank you very much. I appreciate it.
Thank you.
Okay, terrific. Thank you. And let's see, we also have, let's see, maybe we'll do another type question here because I've seen some similar, several questions that are similar here. Again, could you please clarify the difference between what is a shared roof and a non-shared roof. Some folks, might have condominiums that are just a couple of units that are attached with a shared roof, and that, but they might not necessarily understand exactly what constitutes a shared roof.
Yeah, so a shared roof is any roof that's connected and serves more than one unit. So even if it's like a duplex, two next to each other, if the roof is connected, it's a shared roof.
Okay, great. And then let's see, we also have Gary here with the hand raised. Go ahead, Gary, you can unmute yourself. I think. Oh, we might have some audio issues there. Let's see, oh, Gary, are you with us?
Yes.
There you are.
Okay. I was curious about the electrical vehicles charging stations. If a homeowner wanted to put theirs on the outside of their garage, now you're concerned about lawn cutting, snow blowing, those type of things. Is there any type of restriction that we could have in place of the location of those outside?
Not necessarily. If the exterior is a limited common element, then no. If the exterior is a general common element, then yes, you would not need to allow it there.
Okay, thank you.
Yep.
Great. And I see we have reached 1:30 p.m. Thank you so much for your wonderful questions. We really do appreciate that. It adds a lot of value to what we can share here with you together. And we apologize. I know there's a lot of typed questions that we did not get to. We're going to do our best to get back to you via email and follow up with you on those. So for a closing, and as a reminder, please keep your eyes on your email for the link to the video of this presentation. And do feel free to share it with your colleagues. And if this is the first time you have joined us, obviously we'd like to continue the conversation with you. So please do be sure to follow us on social media and connect with us through our email newsletter if you haven't already signed up. You can do that at meglawpllc.com/subscribe. So have a great rest of your day, and we will see you next time.
Thank you, everyone. Thanks for joining us today.
Yes, thanks so much.